Hello everyone, welcome to India4IAS. My name is Shreyas. So last but not the least andange, now we will be solving 2025 Polity PYQs. 2020 in the 2024 ಮಾಡಿದೀವಿ and this is the last hint that we got. Every year ನಾವು ಕ್ವಶನ್ ಪೇಪರ್ನ ಅಟೆಂಪ್ಟ್ ಮಾಡೋಕ್ಕಿಂತ ಮುಂಚೆ PYQsನ ನಾವು ಓದ್ಕೊಂಡು ಹೋಗಬೇಕು, ಅದನ್ನೇ ಮೈಂಡಲ್ಲಿ ಫ್ರೇಮ್ ವರ್ಕ್ ಇಟ್ಕೊಬೇಕು, ಅದರಿಂದನೇ ನಾವು ಹಿಂಟ್ಸ್ನ ಡಿರೈವ್ ಮಾಡಬೇಕು. ಸೊ ದಿಸ್ ಇಸ್ ದ ಲಾಸ್ಟ್ ಹಿಂಟ್ ದಟ್ ವಿ ಹ್ಯಾವ್. ಸೊ 2025 ಪೇಪರಲ್ಲಿ ನೀವು ನೋಡಿದ್ರೆ there are so many questions which derive their roots from the PYQs. PYQs ಅಲ್ಲಿ ಯಾವ ಟಾಪಿಕ್ ಇದೆ, ಲಾಸ್ಟ್ 3 years ಅಲ್ಲಿ ಯಾವ PYQ ಯಾವ ಟಾಪಿಕ್ ಇಂದ ಕ್ವಶನ್ ಬಂದಿದೆ, ಸಿಮಿಲರ್ ಟಾಪಿಕ್ಸ್ ಇಂದ ಕೇಳಿದ್ದಾರೆ ಅಥವಾ ಸಿಮಿಲರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ನ ರಿಪೀಟ್ ಮಾಡಿದ್ದಾರೆ, ಫ್ಯಾಕ್ಟ್ಸ್ ನ ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ. ಸೊ ಕರೆಕ್ಟ್ ರಾಂಗ್ ಅಂತ ಈಸಿಲಿ PYQs ನ ಮಾಡಿದ್ರೆ ಈ ಪೇಪರ್ ಅಲ್ಲಿ ಕೂಡ ಸಾಲ್ವ್ ಮಾಡಬಹುದಿತ್ತು. ಬಟ್ ಒನ್ ಥಿಂಗ್ ವಿಚ್ ಐ ವಾಂಟ್ ಟು ಮೆನ್ಷನ್, 2025 ಪ್ರಿಲಿಮ್ಸ್ PYQ ನ ಹಿಂಗ್ ಮಾಡ್ತಿದೀವಿ. 2025 official key is not yet out. So whatever we do now, we will be doing on what resources we studied. So now ಏನು ಓದಿದೀವಿ ಅದರ ಬೇಸಿಸ್ ಮೇಲೆ we will be solving. But UPSC, like I said, every year 1 or 2 controversial answer key ಜೊತೆ ಬಂದೇ ಬರುತ್ತೆ, and it might happen even this year. But we'll keep that aside and try to solve this paper. So this is the last hint before the real game. So we'll begin with the first question. With reference to Indian polity, consider the following statements. An ordinance can amend any central act. An ordinance can abridge a fundamental right, and an ordinance can come into effect from a back date. So all they're talking about is an ordinance. So ordinance making power ಯಾರ ಹತ್ರ ಇರುತ್ತೆ? ಪ್ರೆಸಿಡೆಂಟ್ ಮತ್ತೆ ಗವರ್ನರ್. ಅಂಡರ್ ಆರ್ಟಿಕಲ್ 213 for president and article 123 for president and article 213 for governor. And when shall an ordinance be made? An ordinance can be made when one of the house or either of the houses are not in session. Only then an ordinance can be made, and an ordinance cannot be used as a parallel power of legislation, as Supreme Court has said. So both the houses session ಅಲ್ಲಿ ಇದ್ದಾಗ ordinance power ನ ಯೂಸ್ ಮಾಡಕ್ ಆಗಲ್ಲ. Ordinance power is done by president or governor on the aid and advice of council of ministers. So this power of president or governor is not discretionary. ಇಷ್ಟು ಬೇಸಿಕ್ಸ್ ನಮಗೆ ಗೊತ್ತಿರಬೇಕು. And what is that ordinance can do? Ordinance can, for example, if you are dealing with the president, then an ordinance, sorry for this, if you are dealing with the president, then an ordinance can be used to make laws on subject which is in union list, or it can be used to make a tax law, but it cannot be used to make changes to the constitution. Ishtu ಮೂರು basics ಇದು ಗೊತ್ತಿದ ಮೇಲೇನೆ we can go to solve this. So we are talking about an ordinance. So an ordinance can amend a central act, which is correct. An ordinance can come into effect from a back date. Yes, law ಕೂಡ retrospectively ಎಷ್ಟೊಂದು ಪ್ರಾವಿಷನ್ಸ್ ನಾವು ಅಪ್ಲೈ ಮಾಡ್ತೀವಿ, that this shall be applicable from so and so. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಈಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ FRA Act, ಫಾರೆಸ್ಟ್ ರೈಟ್ಸ್ ಆಕ್ಟ್, ಅದ್ರಲ್ಲಿ ಕೂಡ ಮೆನ್ಷನ್ ಮಾಡಿದೀವಲ್ವಾ, someone who has been cultivating forest for 3 generations or 75 years before 2005, ಆ ತರ ಒಂದು ಡೇಟ್ ಕೊಡ್ತೀವಿ. ಸೊ ದಟ್ ಈಸ್ retrospectively applying. So ordinance can also be used for that, and ordinance can also be used for making tax laws. If you want to impose, if you want to make changes to the tax law, that also you can do through mechanism of ordinance. But an ordinance cannot be used for constitutional amendment act, because if that is been made, then the executive might misuse it also. And when we speaking of ordinance, the ordinance needs approval once the house reassembles, and it will have a time of 6 weeks before which it has to get the approval. So 6 weeks approval, 6 weeks ಒಳಗಡೆ approval ಬೇಕು ordinance continue ಆಗಬೇಕಂದ್ರೆ. So sometimes when the Lok Sabha or when the house is not in session, the maximum duration for which the house cannot be in session is 6 months. So 6 months, 6 weeks is the maximum period when an ordinance can still be there without getting the approval from the houses. So idu kuda basics ಗೊತ್ತಿರಬೇಕು. Now we'll keep the basics aside, we'll look at this. It can amend central act, it can come into effect from a back date. Idu correct, idu correct. Now whatever I said, use that and apply it to the second statement. ಇಲ್ಲಿ application ಬೇಕು. Ordinance can abridge a fundamental right. What is fundamental right? Fundamental right ಅಲ್ಲಿ changes ಮಾಡಬೇಕಂದ್ರೆ ಯಾವ್ದ್ರಲ್ಲಿ changes ಮಾಡಬೇಕು? We need to make changes to the constitution. And like I said, ordinance cannot be used for constitutional amendment. 2 becomes wrong, 1 and 3 is the answer. So constitution ನ ಅಮೆಂಡ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅನ್ನೋದು ನಮ್ಮ ಮೈಂಡ್ ಅಲ್ಲಿ ಇರುತ್ತೆ. ಆದ್ರೆ ಇಲ್ಲಿ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ ಚೇಂಜಸ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಕೂಡ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬರ್ಬೇಕನ್ನೋದು is the application part. Like I said, it can be used to amend a tax law. Okay, it can be used to amend a tax law, modify, repeal any act of parliament or ordinance, but it cannot be used for constitutional amendment. So similar thing will apply for the governor, that state list mail ಮಾಡಬಹುದು and so on. Tax law ಕೂಡ ಮಾಡಬಹುದು and so on. Now with reference to India, which of the following are established under the provisions of constitution? PYQ we already spoke about that. I asked you to remember which are the constitutional bodies. Constitutional bodies ಯಾವ್ಯಾವ್ದು ಅಂತ ಜ್ಞಾಪಕ ಇಟ್ಕೊಳ್ಳಿ. ಇದನ್ನೇ indirect way ಅಲ್ಲಿ which of the following are established under the provisions of constitution of India? Nothing but constitutional bodies they are asking because they are given bodies. Interstate Council established under Article 263 on the recommendation of Sarkariya Commission. We know this. Administrative Reforms Commission had also suggested it before Sarkariya Commission. So, idu correct. National Security Council is not constitutional. Zonal Council is a statutory body which is established under State Reorganization Act of 1956. Zonal Council is headed by Home Minister. Idu namige chennagi gottide. See, North Eastern Council ಬಗ್ಗೆ ಮಾತಾಡಿದ್ವಿ last year. ಅದರ ಜೊತೆ zonal council ಬಗ್ಗೆ ಕೂಡ ನಾವು ಓದಿರಬೇಕು because zonal council is more important. So 2 is wrong, 3 is wrong, answer becomes only 1. Now what about, now when they have spoken about National Security Council in this year or about zonal council among the options, so in the next year this becomes more important. So options alli ಯಾದ answer ಇಲ್ಲ ಅದರಿಂದ next year usually UPSC questions formulate ಮಾಡೋ chances ಜಾಸ್ತಿ ಇರುತ್ತೆ. So we'll have a basic idea about National Security Council. It is non-constitutional and non-statutory body. So it is a body that is been established by executive resolution. And what does it do? Obviously, name is security. So it does the security management within the country. And NSC is been headed by the Prime Minister of India. Istu basic gottira saku. Rest about Interstate Council and about Zonal Council we have already come across so many times. So we'll move to the next question. This was also a bouncer sort of question when we attempted this in the actual exam. We'll see the question. Arunachal Pradesh. The capital of Arunachal Pradesh is Itanagar. The capital is named after a fort. How can we know about this unless and until we are not someone from Arunachal Pradesh? And state has 2 national parks. See, national park gottu, wildlife sanctuary gottu. Yad wildlife sanctuary, yad national park. ಇದು ತುಂಬಾ ಕಷ್ಟ. ನ್ಯಾಷನಲ್ ಪಾರ್ಕ್ ವೈಲ್ಡ್ ಲೈಫ್ ಸೆಂಚುರಿ ಡಿಫರೆನ್ಶಿಯೇಟ್ ಮಾಡೋದು ಕಷ್ಟ. ರಮ್ಸರ್ ಸೈಟ್ಸ್ ಯಾರಂತ ಹೇಳ್ಬೋದು, ಟೈಗರ್ ರಿಸರ್ವ್ ಯಾರಂತ ಹೇಳ್ಬೋದು. ಸೊ ದಿಸ್ ವಾಸ್ ಅ ಡಿಫಿಕಲ್ಟ್ ಥಿಂಗ್ ಸ್ಪೆಷಲಿ ವೆನ್ ವಿ ಹ್ಯಾಡ್ ಟು ಥಿಂಕ್ ಡ್ಯೂರಿಂಗ್ ದ ಆಕ್ಚುಯಲ್ ಎಕ್ಸಾಮ್ ಕಂಡೀಷನ್. ಸೊ 2 ಇದೆಯಾ, 3 ಇದೆಯಾ, 4 ಇದೆಯಾ ಅದು ಹೇಳೋದು ತುಂಬಾ ಕಷ್ಟ. ಇನ್ಸ್ಟೆಂಟ್ ನ್ಯಾಷನಲ್ ಪಾರ್ಕ್ ನ ಕೊಟ್ಬಿಟ್ಟು ಅದು ಎಲ್ಲಿದೆ ಅಂದ್ರೆ ಈ ಸ್ಟೇಟ್ ಅಲ್ಲ ಅಂತ ಹೇಳ್ಬೋದಿತ್ತು. ಸೊ ದಿಸ್ ವಾಸ್ ಅ ಡಿಫಿಕಲ್ಟ್ ಟಾಸ್ಕ್ ಟು ಬಿ ಡನ್. ಲುಕ್ ಎಟ್ ದ ಸೆಕೆಂಡ್ ಥಿಂಗ್. ನಾಗಾಲ್ಯಾಂಡ್. ದ ಸ್ಟೇಟ್ ಕೇಮ್ ಇನ್ ಟು ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ಆನ್ ದ ಬೇಸಿಸ್ ಆಫ್ ಅ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಕ್ಟ್. ಓಕೆ. Tripura, initially a Part C state. Now we know what Part C state is. Munche princely states na Part C litiro. It became a central administrated territory within the reorganization and later attained the status of full-fledged state. So what it's telling is initially it was Part C, later it became a union territory, later it became a state. This is what it is telling. So ee question alli nodidre 1 2 2 3 ಆ ತರನೂ ಇಲ್ಲ. ಈಸಿಲಿ ಅದರ ಎಲಿಮಿನೇಟ್ ಮಾಡಿ ಯಾದನಾರು ಗೆಸ್ ತಗೊಳಕ್ಕೆ. So we need to know all these 3 statements, only then we could have attempted this. So this was a difficult question. Either we could have left this question, or if we were forced to attempt this question, how is that we could have attempted? Nodana ena smart guess work ಮಾಡಬಹುದಿತ್ತಾ ಅಂತ. See, Nagaland, if we recall Article 371 which gives special provisions to the state, Article 371 clause A ಅಲ್ಲಿ Nagaland ಗೆ ಸ್ಪೆಷಲ್ ಸ್ಟೇಟಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಂಡ್ ಇಫ್ ಯು ನೋ ದ ಇಂಟಿಗ್ರೇಷನ್ ಆಫ್ ನಾರ್ತ್ ಈಸ್ಟರ್ನ್ ಪಾರ್ಟ್ಸ್ ವಾಸ್ ಡಿಫಿಕಲ್ಟ್ ವಿತ್ ದ ಮೇನ್ ಸ್ಟ್ರೀಮ್ society because of the British influence. And in that sense we can think that yes, Nagaland might have been given certain special provisions so that it agrees to join with the Indian Union. So the state came into existence on the basis of Constitutional Amendment Act. It did came into existence because of Constitutional Amendment Act which added the Article 371. So Nagaland na join ಮಾಡಬೇಕಂದ್ರೆ Constitutional Amendment Act ಮಾಡಿದ್ವಿ. Nagaland Constitutional Amendment Act ಅಂತ ಮೈಂಡ್ ಬಂದಾಗ 371 ಏನಾದ್ರು ಬಂದಿದ್ರೆ we could have taken this to be correct. ಇದು ಎಕ್ಸಾಮ್ ಟೈಮ್ ಅಲ್ಲಿ ಮೈಂಡ್ ಬಂದಿದ್ರೆ. Next, Tripura. Now if we have gone across the chapter 5 of Lakshmikant which is union and the states, then they are also in the PYQs or in the test series I had told you to remember which are the union territories which became state or which were the foreign territories which became a part of Indian territory. Idu namage gottirbeku. So which were the UTs, union territories, which became state. I asked you to remember this. So Tripura is one, Manipur is one, Mizoram is another one, Goa is another one, Himachal Pradesh is another one. So these 5 were union territories which later became states. So Tripura, initially Part C, princely state, possible thing. So centrally administered territory, that means it was union territory, but later it got full-fledged status. So ee censor kuda we could have taken this to be correct. E word correct tagond mele there is very difficult chances to deduce this. So 2 ಮತ್ತೆ 3 ಮತ್ತೆ 50-50 ಮಾಡಬೇಕಿತ್ತು if you were forced to attempt this. And the answer to this is also correct. So this was a very difficult question to be attempted. See, Arunachal Pradesh ಅಲ್ಲಿ Namdappa. ಈಗ Namdappa ನ್ಯಾಷನಲ್ ಪಾರ್ಕ್ ಅಂತ ಮ್ಯಾಚ್ ದ ಫಾಲೋಯಿಂಗ್ ಕೊಟ್ಬಿಟ್ಟು ಅರುಣಾಚಲ್ ಪ್ರದೇಶ್ ಅಂತ ಕೊಟ್ಟಿದ್ರೆ easily we would have been able to answer. And Mauling. Now Mauling itself, now most of us may not know where this Mauling is lying. And here they have formulated such a difficult sentence. So it becomes very difficult. Answer to this question is all 3. So it was a question meant to be left. ಅಥವಾ ರಿಸ್ಕ್ ತಗೊಬೇಕಂದ್ರೆ 50-50 ಮಾಡಬೇಕಾಗಿತ್ತು. That too based on smart guesswork. Consider the following statements. The Constitution of India explicitly mentions that in certain spheres the governor of a state acts in his or her discretion. Explicitly mentions. Okay. The President of India can on his or her own reserve a bill passed by the state legislature for his or her consideration without it being forwarded by the governor. Without it being forwarded by the governor. ಈ ತರ without ಅಂತ ಬಂದಾಗ extra ಕಾನ್ಶಿಯಸ್ ಆಗಬೇಕು, because traps are usually given here. ಮುಂಚೆ ಈ ತರ ಟ್ರ್ಯಾಪ್ ಕೊಟ್ಬಿಟ್ಟು 3-4 years ಮುಂಚೆ ಟ್ರ್ಯಾಪ್ ಕೊಟ್ಬಿಟ್ಟು ಪಕ್ಕ ರಾಂಗೇ ಮಾಡ್ತಿರೋ. ಈಗ ಟ್ರ್ಯಾಪ್ ಕೊಟ್ಟರು ಕೂಡ ಎಕ್ಸ್ಟ್ರಾ ಕಾನ್ಶಿಯಸ್ ಆಗಿರ್ಬೇಕು, ಯಾಕಂದ್ರೆ ಕರೆಕ್ಟ್ ಕೂಡ ಮಾಡ್ತಿದ್ದಾರೆ. This has been seen from the last 2-3 years, 2023 pattern ಇಂದ. So we will have to be very careful. President can act upon the state legislature bill only when the governor will reserve it. Article 200 ಅಲ್ಲಿ ಓದಿದೀವಿ. ಈ ಪೇಪರ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಹಿಂಟ್ ನಾನು ಈಗಲೇ ಕೊಡ್ತೀನಿ. ಆಸ್ ವಿ ಸಾಲ್ವ್, UPSC ತುಂಬಾ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ನ ಪಿಕ್ ಮಾಡ್ಬಿಟ್ಟು ಅದನ್ನೇ ಉಲ್ಟಾ ಮಾಡಿದೆ. ಯಾವುದು ಈ ತರ ಆಗತ್ತೆ ಅಂತ ಇದೆ, ಈ ತರ ಆಗಲ್ಲ ಅಂತ ಕೊಟ್ಟಿದೆ. ಸೊ ವಿಲ್ ಗೋ ಆನ್ ಸೀಯಿಂಗ್ ಇಟ್ ಆಸ್ ವಿ ಮೂವ್ ಅಹೆಡ್. ಸೊ ವಿದೌಟ್ ಇಟ್ ಬೀನ್ ಫಾರ್ವರ್ಡೆಡ್ ಬೈ ದ ಗವರ್ನರ್ ಅಂಡರ್ ಆರ್ಟಿಕಲ್ 200 ಹ್ಯಾಸ್ ಟು ಫಾರ್ವರ್ಡ್ ಇಟ್. ಓನ್ಲಿ ದೆನ್ ಕ್ಯಾನ್ ದ ಪ್ರೆಸಿಡೆಂಟ್ ಆಕ್ಟ್ ಅಪಾನ್ ಇಟ್. ಆರ್ ಎಕ್ಸಾಮ್ ಟೈಮಲ್ಲಿ ಪ್ರೆಸಿಡೆಂಟ್ ಅಲ್ವಾ, ಪಾಸಿಬಲ್ ಇದೆ ಅನ್ಬಿಟ್ಟು ಅನ್ಕೊಂಡ್ಬಿಡ್ತೀವಿ. ಸೊ ದಿಸ್ ಇಸ್ ರಾಂಗ್. ಆಲ್ಸೋ the Constitution of India explicitly mentions, now this explicitly word has been given, mentions that in certain sphere the governor of a state acts on his or her discretion. There are 2 types of discretion. One is constitutional discretion, one is situational discretion. Constitutional discretion has been mentioned both for president as well as governor, that when there are certain grounds, then the president or the governor can act on their discretion, such as when there is no majority in the house, then allowing a certain party to form the government, or when a house does not have a majority, then dissolving the house. So these are the discretionary powers which the president and the governor has, and this has been explicitly mentioned in the constitution. Last year question alli president constitutional discretion ಬಗ್ಗೆ ಮಾತಾಡಿದ್ವಿ, ಅದನ್ನೇ ಇಲ್ಲಿ ನೋಡಿ governor constitutional discretion ಬಗ್ಗೆ ಹೇಳಿದ್ದಾರೆ. So the present is just a continuity of the past. Similar things from the past PYQs they have picked it up and they have asked. Answer becomes only one. Like I said, Article 163, if a question arises whether a matter is discretionary, the governor's decision shall be final. So discretion is allowed in certain matters, such as reserving of bill under Article 200, reporting to the president under Article 356, and so on. So governor would reserve a bill under Article 200, and only then can the president consider it. See, like I said, controversial keys barbodu. These are the things. So we have taken out this solution based on the resources or the common resources that we study. Now if UPSC comes out with a controversial key, now every institute will formulate their own answer based upon their key. Avag change agbodu, but this is what, let's hope this will be the answer. Provision in the Constitution of India and the provision of the Constitution of India, and we need to match. Separation of judiciary and executive. I think this was 2020 or 2021 question. I said it is DPSP. It is a direct question that has been picked up. Article 50, separation of executive and judiciary. Like we already spoke, constitutional supremacy irbeku, separation of powers irbeku, separation of powers irre liberty irutte. So for all this, we need separation of executive judiciary. So many questions have been asked. Based on this theme, just slightly try to vary. Valuing and preserving of rich heritage of our composite culture, fundamental duty under Article 51A. ಇದು ಕೂಡ ನಮಗೆ ಬೈ ಹಾರ್ಟ್ ಇರಬೇಕು. Article 51A. Prohibition of employment of children below the age of 14 years in factories, which come under Article 24, which is a fundamental right. Answer is all three. ಈ ತರ questions we cannot afford to make mistake. So please have a control over these important topics. We'll move to next question. Consider the following statements with reference to the Constitution of India. If an area in a state is declared as scheduled area under 5th schedule, I think this is the second or third question that we are solving on 5th schedule among the 6-year PYQs that we did. So area is said to be scheduled area under 5th schedule. So what are the things? State government loses its executive power in such an area and a local government assumes total administration. One thing it is telling, it is extreme thing which it is telling that total administration. Okay. The union government can take over the total administration of such areas under certain circumstances based on the recommendation of governor. Like I said, I gave you a hint. In 2025 paper, as we see, there are so many things which are not at all possible, and UPSC has formulated a sentence telling that it can do it, it can do it. Anbut itara kotti wrong marside. See, 5th schedule anta declare madadaga state government would still have power, and the center is also empowered to give executive directions to the state government, and there is a governor who would have power to make regulations when it comes to 5th schedule. But the state does not lose its power, nor does the local body get total administration. So this is wrong. The union government can take over the total administration of such areas under circumstances based on the recommendation of governor. No, that is also not possible. Only the governor can make regulations exercising power over these 5th schedule areas. The union government cannot take over the total administration. Adre il trap in martidare munche nodi, we used to pick certain circumstances anta ee tara generic thing idre ಅಥವಾ one of the above ee tara generic things idre that used to be correct. But 2025 pattern nodre these things na wrong madakoskara UPSC ee tara kottu next trap ಕೊಡ್ತಿದೆ. So ಇದು knowledge basis ಮೇಲೆ ಆನ್ಸರ್ ಮಾಡೋ ಕ್ವಶನ್. ಕಂಪ್ಲೀಟ್ ಗೆಸ್ ವರ್ಕ್ ಮಾಡೋರು ಇದನ್ನು ಕರೆಕ್ಟ್ ತಗೊಂತಾರೆ. So ಅದೇ, so UPSC is changing its pattern, we need to be careful. Administration of these areas continues under the executive authority of the state. Like I said, 5th schedule empowers the government to administer these areas with special powers. He can make regulation, he can even modify or exclude the application of law, be it made by parliament or by state legislature. We'll move to next question. Consider the following subjects under the Constitution of India. List 1, Union list, list 1, 7th schedule correct. Extent of executive power of state and conditions of the governor's office. So constitutional amendment, this is the third or fourth question that we are solving from the last 6-year PYQs. Constitutional amendment with respect to which of the following requires a ratification of legislatures of not less than one of the states. So they are talking about Article 368, the second category, where half of the state legislatures need to provide their ratification. So ನಾನು ಹೇಳಿದ್ನಲ್ಲ, ಈಗ ಸಿಂಪಲ್ ಮೆಜಾರಿಟಿ ಯಾದಕ್ಕೆ ಬೇಕು, ಸ್ಪೆಷಲ್ ಮೆಜಾರಿಟಿ ಯಾದಕ್ಕೆ ಬೇಕು, ಸ್ಪೆಷಲ್ ಮೆಜಾರಿಟಿ ವಿತ್ ರಾಟಿಫಿಕೇಶನ್ ಆಫ್ ಸ್ಟೇಟ್ಸ್ ಯಾದಕ್ಕೆ ಬೇಕು, ಒಂದು ಬ್ರಾಡ್ ಐಡಿಯಾ ನಮಗಿತ್ತು. ಆದರೆ ದೇ ಹ್ಯಾವ್ ಪಿಕ್ಡ್ ಅಪ್ ಸಬ್ಜೆಕ್ಟ್ಸ್ ವಿಚ್ ಆರ್ ನಾಟ್ ಮೆನ್ಷನ್ಡ್ ಇನ್ ದ ಕನ್ವೆನ್ಷನಲ್ ಬುಕ್ಸ್ and they are trying to understand if you are able to make the smart guesswork or not. So extent of executive power of the state, extent of legislative power of the state or extent of executive power of the state, ಅದನ್ನ ಎಫೆಕ್ಟ್ ಮಾಡಬೇಕಂದ್ರೆ 7th schedule ಬೇಕಾಗುತ್ತೆ, because it is an important power. So whenever there is a federal feature that is being involved, then ratification of states important ಆಗುತ್ತೆ. So some matter in which both center as well as the state has interest, ಆ ಕೇಸಲ್ಲಿ ratification ಬೇಕಾಗುತ್ತೆ, because we do not want to harm the state interest just by giving all the power to the parliament. So extent of executive power or legislative powers of state ಮಾಡಬೇಕಾದ್ರೆ we need states consent also. Conditions of governor's office, condition of president's office or governor's office, we need ratification of the states, because governor will be an important agent who will be dealing both with the center as well as the states. So we cannot give the conditions of office of governor completely under the union list. I mean completely under the center's control. This is also correct. See, now list 1 is 7th schedule. If you have studied in Lakshmikant itself, if any changes needs to be made to the 7th schedule, then ratification of the states is needed, be it union list, state list or concurrent list. Answer is D. But first instance alli bari union list na ಓದ್ಬಿಡ್ತೀವಿ, wrong ಮಾಡ್ಕೊಂತೀವಿ. ಅದಕ್ಕೆ ಇದನ್ನ ಕೂಡ ಕೊಟ್ಟಿದ್ದಾರೆ in the 7th schedule, because if you memorize 7th schedule changes ಮಾಡಬೇಕಂದ್ರೆ ratification of states ಬೇಕಂತ ನಾವು ಓದಿರ್ತೀವಿ. ಬಟ್ ಎಕ್ಸಾಮ್ ಟೆನ್ಷನ್ ಅಲ್ಲಿ ಬರೀ ಯೂನಿಯನ್ ಲಿಸ್ಟ್ ನೋಡ್ಬಿಟ್ಟು ಯೂನಿಯನ್ ಲಿಸ್ಟಾ ಸೆಂಟರ್ ಪರ್ಮಿಷನ್ ಬೇಡ, ಬರೀ ಸ್ಟೇಟ್ ಪರ್ಮಿಷನ್ ಬೇಡ, ಬರೀ ಸೆಂಟರ್ ಮಾಡ್ಬೋದು ಅಂತ ಥಿಂಕ್ ಮಾಡ್ಬಿಡ್ತೀವಿ. ಡು ನಾಟ್ ಮೇಕ್ ದಟ್ ಮಿಸ್ಟೇಕ್. ವಿಲ್ ಸಿ ದ ನೆಕ್ಸ್ಟ್ ಕ್ವಶನ್. ವಿತ್ ರೆಫರೆನ್ಸ್ ಟು ದ ಇಂಡಿಯನ್ ಪಾಲಿಟಿ, ಕನ್ಸಿಡರ್ ದ ಫಾಲೋಯಿಂಗ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್. The governor of a state is not answerable to any court for the exercise and performance of powers and duties in his or her office. This is correct. Idinna double think mabedi. This is the first statement. Next statement kottilla. For example, governor is not answerable because there should be independence for his office. This is what it means. It doesn't mean that whatever governor does, nobody questions it. Judicial review apply agala. This is not what it means. It is telling sentence in the first instance. However, ಇಲ್ಲಿ ಬರಬೇಕಿತ್ತು. However, ಈಗ ನಾವು ಬುಕ್ಕಲ್ಲಿ ಓದಿದ್ರೆ ಈ ಸೆಂಟೆನ್ಸ್ ಕೊಟ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಕೊಡ್ತಿದ್ರು. However, if the decision of the governor is found to be malified or arbitrary, then the court shall intervene through the process of judicial review. ಈ ತರ ಬುಕ್ಕಲ್ಲಿ ಕೊಡ್ತಾರೆ. ಆದ್ರೆ ಇಲ್ಲಿ ಫಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ನ ಪಿಕ್ ಮಾಡಿದ್ದಾರೆ. ಸೊ ಫಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ನ ಪಾಸಿಟಿವ್ ನೋಟ್ ಅಲ್ಲಿ ತಗೊಬೇಕು. ದಿಸ್ ಇಸ್ ಕರೆಕ್ಟ್. No criminal proceedings shall be instituted or continued against the governor during his term of office. This is also correct. See, governor and president, they are protected under Article 361 and both these provisions are directly mentioned from the Constitution. 2025 paper ಅಲ್ಲಿ ಇನ್ನೊಂದು ಸ್ಪೆಷಾಲಿಟಿ ಏನು ನೀವು ನೋಡಿದ್ರೆ, there are so many questions or statements that are picked directly from the Constitution of India. Constitution of India directly provide ಮಾಡುತ್ತೆ, directly pick ಮಾಡಿ correct or wrong ಅಂತ ಹೇಳಿದ್ದಾರೆ. Members of state legislature are not liable to any proceedings in any court in respect of anything said within the house. This is also correct. And this is a privilege, just like parliamentary privilege 105 ಅಲ್ಲಿ ಇರುತ್ತೆ. State legislature, member of state legislature also a privilege under 194, and this is a privilege. So this was a easy question. Answer is 1, 2 and 3. Like I spoke, first two statements are covered under Article 361. Third statement is covered under Article 194. Next question. Consider the following statements with regard to the pardoning power of the president. See, idu nam gottirbeku. One, pardoning power, one, the power of commutation. Next, remission, reprieve, respite. So what are these? Pardoning andre completely sentence ne cancel ಮಾಡುತ್ತೆ. Commutation andre replace ಮಾಡುತ್ತೆ. For example, death penalty idre adana imprisonment ಜೊತೆ ಮಾಡುತ್ತೆ. So remission andre sentence na same ittu years na kadme ಮಾಡುತ್ತೆ. And likewise, reprieve and respite. Reprieve ಯಾವಾಗ it is similar to commutation, sentence ನ ಕಡಿಮೆ ಮಾಡ್ತಾರೆ, but for a special reason such as pregnancy, mental illness and so on. Reprieve ಅಂದ್ರೆ, reprieve is usually just for an extension of time so that they can apply for pardoning, right? So this is basics we need to know. So we are talking about the pardoning power of the president. So pardoning power of president ಬಗ್ಗೆ ಓದಿದಾಗ ಮೈಂಡ್ ಗೆ ಬಂದ್ಬಿಡಬೇಕು, president ಮತ್ತೆ governor ಮಧ್ಯ pardoning power ಅಲ್ಲಿ difference ಇದೆ, both are not the same. The exercise of this power by the president can be subjected to limited judicial review. Yes. Limited judicial review in this means just that the pardoning power of the president would be questioned only when it is found to be malified or arbitrary. Only then court will intervene, or else it won't intervene. That is what it means. That's it. The president can exercise his power without the advice of central government. He cannot. So ಅದೇನಲ್ಲ, ಎಲ್ಲಿ ಏಡೇನ್ ಅಡ್ವೈಸ್ ಬೇಕು, ಎಲ್ಲಿ ಏಡೇನ್ ಅಡ್ವೈಸ್ ಬೇಡ. ಸೊ ಪ್ರೆಸಿಡೆಂಟ್ ಯಾವಾಗ ಡಿಸ್ಕ್ರಿಷನರಿ ಪವರ್ಸ್ ಅಪ್ಲಿಕೇಬಲ್ ಆಗುತ್ತೆ ಅಂತ 2-3 ಕಂಡೀಷನ್ಸ್ ಜ್ಞಾಪಕ ಇಟ್ಕೊಂಡಿದ್ರೆ, ಇನ್ ರೆಸ್ಟ್ ಆಲ್ ಆಫ್ ದ ಕೇಸಸ್ ಏಡ್ ಅಂಡ್ ಅಡ್ವೈಸ್ ಇಸ್ ನೀಡೆಡ್. ಸಿ, ಲಾಸ್ಟ್ ಇಯರ್ ಕ್ವಶನ್ ನ ಸಾಲ್ವ್ ಮಾಡಿದ್ರೆ ಏಡ್ ಅಂಡ್ ಅಡ್ವೈಸ್ ಗೊತ್ತಾಗ್ತಿತ್ತಾ, ಈ ವರ್ಷ ಸಾಲ್ವ್ ಮಾಡಬಹುದಿತ್ತು. ದಿಸ್ ಇಸ್ ಹೌ ವಿ ಕ್ಯಾನ್ ಇಂಟರ್ಲಿಂಕ್. Pardoning power of president, see it as Supreme Court has said in Kehar Singh that it shall be reviewed to ensure procedural fairness. Also it has said that the grounds when such as arbitrariness, malified is been done, then the pardoning power shall be reviewed, or else it shall not be reviewed. So that is why limited judicial review. Consider the following statements. On the dissolution of House of People, the Speaker shall not vacate his or her office until immediately before the first meeting of House of People after the dissolution. Simple thing, correct. According to provisions of Constitution of India, member of House of People on being elected as the Speaker shall resign from his or her political party. It does not happen in India, though we need it. Speaker of House of People may be removed from his or her office by a resolution of People of House passed by majority of all the then members of the House. Okay, nothing but all the then members means effective majority. Effective majority. So, 2 wrong agide, 2 wrong, 2 wrong, 2 wrong. Answer is C. See, whenever House is dissolved, do not try to confuse. For instance, whenever Lok Sabha is been dissolved, the Speaker will continue. He shall not vacate his office because the Speaker has to be there. Once the Lok Sabha dissolve agite, next House create agate. So, next House oath and all those process needs to be taken care of. So, the Speaker will be there and next House will vacate his office only when the next government that is formed would appoint a new Speaker. Until then, it's been done to avoid the legislative vacuum. But when the Speaker completes his term of 5 years, in that case, Speaker pro tem anta one temporary member na appoint ಮಾಡ್ತಾರೆ. That is only for very short duration until the next government is made to take in charge. So that happens when the Speaker has completed his term. Avag Speaker pro tem ಬರ್ತಾರೆ. Are Lok Sabha dissolve ಆದರೆ that is this Speaker itself would until the next government takes charge. And Speaker is a partisan member when it comes in India. For example, when we have BJP government at the center, then the Speaker will be from the BJP government. So he is a partisan person. He belongs to a particular party. So often it becomes difficult for him to act neutral. So that is why this issue against the Speaker has been happening, where the opposition is blaming the Speaker. That is taking up a partisan role and is not neutral or impartial. So Speaker should have resigned from his or her political party. But that is not the case in India, whereas that is the case when it comes to countries like UK. So Office of Speaker mains answer bardak, this is one of the recommendations which we need to put, that Speaker needs to uphold the impartiality of the Speaker. Speaker needs to resign from his political party once he is elected to this office. ಮತ್ತೆ ಸ್ಪೀಕರ್ ನ ರಿಮೂವ್ ಮಾಡಬೇಕಂದ್ರೆ ಮೆಜಾರಿಟಿ ಆಫ್ ಆಲ್ ದ ದೆನ್ ಮೆಂಬರ್ಸ್ ಮಾಡಬೇಕು. ಮತ್ತೆ ನೋ ರೆಸಲ್ಯೂಷನ್ ಶಲ್ ಬಿ ಡನ್. ಅದೇ 14 days ಅಟ್ ಲೀಸ್ಟ್ ಟೈಮ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿರಬೇಕು. ಸ್ಪೀಕರ್ ನ ರಿಮೂವ್ ಮಾಡಂಗಿದ್ರೆ 14 days ನೋಟಿಸ್ ಕೊಡಬೇಕು. ಆಮೇಲೆ ಯು ಕ್ಯಾನ್ ಮೂವ್ ದ ರೆಸಲ್ಯೂಷನ್ ಫಾರ್ ಹಿಸ್ ರಿಮೂವಲ್. So these are basic things. Same thing which I said. We look into the next question. If any question arises as to whether a member of House of the People has become subject to the disqualification under the 10th schedule. 10th schedule ಯಾವಾಗ ಆಡ್ ಮಾಡಿದ್ದು 52nd amendment, constitutional amendment. Then the president's decision in accordance with the opinion shall be final. See ನೋಡಿ, ಮೇನ್ಸ್ ಅಲ್ಲಿ ನಾವು ಎಷ್ಟೊಂದು ರೆಕಮೆಂಡೇಶನ್ ಬರಿತೀವಲ್ವಾ, ಈ ತರ ಇರೋದು ಈ ತರ ಆಗ್ಬೇಕು ಅಂತ, ಆ ರೆಕಮೆಂಡೇಶನ್ ಆರ್ ವೇ ಫಾರ್ವರ್ಡ್ ನ ಪಿಕ್ ಮಾಡಿ ಎಷ್ಟೊಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಫಾರ್ಮುಲೇಟ್ ಮಾಡಿದ್ದಾರೆ. ಒನ್ ಇಸ್ ದಟ್ ಅಬೌಟ್ ದ ಸ್ಪೀಕರ್ ಬೀಂಗ್ ಪಾರ್ಟಿಸನ್ ಪರ್ಸನ್. ಸೆಕೆಂಡ್ ಇಸ್ ದಿಸ್, ವೆನ್ ಇಟ್ ಇಸ್ ಅಬೌಟ್ 10th schedule 52nd constitutional amendment where it is dealing with anti-defection, then it is the speaker whose decision is final. But what is the way forward that we want? We want the president to decide it in consultation with the election commission. Illi president decide ಮಾಡ್ತಾರೆ already ಹೇಳಿದ್ದಾರೆ, that is still it has not happened, and there is no mention of the word political party in the constitution. See, ಈ ತರ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಏನಿದೆ ಏನಿಲ್ಲ ಅಂತ ಬಂದಾಗ please be careful whether it is talking about mentioning, whether it is talking about defining, or whether it is talking about classifying or regulating or whatever such words. Classifying, regulating. Mention constitutional ತುಂಬಾ ಕಡೆ ಆಗಿದೆ. For example, parliamentary committees, they have been mentioned in the constitution, but there is no defining or detailed provisions which have been made. So mention ತುಂಬಾ ಕಡೆ ಆಗಿದೆ, but it is not defined. Similar thing is applicable in this case. There is no mention of the word ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇಲ್ಲಿ ನೆಗೆಟಿವ್ ಕಾನೋಟೇಷನ್ ಅಂತ ಯೂಶುವಲಿ ವಿ ಟೇಕ್ ಇಟ್ ರಾಂಗ್. ಬಟ್ ಈ ತರ ಥಿಂಕ್ ಮಾಡಿ, ಮೆನ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರಾ, ಡಿಫೈನ್ ಕೊಟ್ಟಿದ್ದಾರಾ, ಕ್ಲಾಸಿಫೈ ಕೊಟ್ಟಿದ್ದಾರಾ. ಡಿಫೈನ್ ಅಂಡ್ ಕ್ಲಾಸಿಫೈ ಮೋಸ್ಟ್ ಆಫ್ ದ ಕೇಸಸ್ ಅಲ್ಲಿ ರಾಂಗೇ ಇರುತ್ತೆ. ಮೆನ್ಷನ್ ಸರ್ಟನ್ ಕೇಸಸ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಇರುತ್ತೆ, ಆದ್ರೆ ಈ ಎರಡು ಮೋಸ್ಟ್ ಆಫ್ ದ ಕೇಸಸ್ ರಾಂಗ್ ಇರುತ್ತೆ. There is a mention of the word political party and it was also added by 52nd amendment only. So someone who has studied 52nd amendment from the constitution book, that person would have studied the word political party also in that lines. So adike formulate madidare, ella questions constitution articles indane pick madidare. So we can see that thing. So political party ಬಗ್ಗೆ 52nd amendment they have made a mention, but they have not defined it or made particular provisions for it, because all those provisions are made under RP Act of 1951, defining political party, regulating it, what is it subjected to, what is it not subjected to. Yella RP Act 1951 nal bandide. Constitution there is only mention, and that it was not present in the original constitution. It was added by 52nd amendment. Just like I said, cabinet word munche irlilla original constitution alli, but it got later added by 42nd constitution amendment. We'll move to next question. Like I said, registration and functioning of political parties, they are regulated through laws such as Representation of People Act 1951. Consider the following statements. Statement 1, in India, state governments have no power to making rules for grant of concession in respect of extraction of minor minerals, even though such minerals are located in the territories. Same thing among the last 6-year PYQs that we have solved, 5-year PYQs actually, this is the 6th. PYQ ಅಲ್ಲಿ ಕೂಡ we already spoke about minor minerals. So minor minerals ಬಂದಾಗ power ಯಾರ ಹತ್ರ ಇರುತ್ತೆ? State government under ಇರುತ್ತೆ. This is wrong. When we are dealing with the minor minerals, the power to regulate, the power to provide for extraction of minerals, the power to prevent illegal extraction of such minerals, all such powers should be minor minerals ಯಾದಂತ ಕೂಡ ನಾವು ಆಲ್ರೆಡಿ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ವಿ previous classes ಅಲ್ಲಿ. So when one is wrong, we need not think of any other thing. One is wrong, answer is D. Done. One statement in the deduce ಮಾಡಬಹುದು. So these sort of questions are the easiest, but ಈ word statement ಅಲ್ಲಿ ಒಂದಾದ್ರೂ wrong ಇರಬೇಕು ಮತ್ತು ಅದು ನಿಮಗೆ ಗೊತ್ತಿರಬೇಕು. In India, central government has the power to notify minor minerals under the relevant law. This is correct. Why? We'll see. So it is the MMDR Act which is enacted by the Parliament. So under Mines and Minerals Development Act, they have classified minerals into major minerals which shall be the responsibility of the center, and they have classified it into minor minerals which shall be the responsibility of the state. So major minerals yadu? Copper, nickel, iron, limestone, all these are major minerals. Minor minerals yadu? Mica, quartz, agate, barytes, dolomite, sand, conundrum, fire clay, gypsum, laterite, all these are minor minerals. Most common ನಾವು ಬರೋದು ಮೈಕಾ ಅಕ್ರಾಸ್ ಬರ್ತೀವಿ, ಸ್ಯಾಂಡ್ ಅಕ್ರಾಸ್ ಬರ್ತೀವಿ, ಕ್ವಾರ್ಟ್ಸ್ ಅಕ್ರಾಸ್ ಬರ್ತೀವಿ, ಜಿಪ್ಸಮ್ ಅಕ್ರಾಸ್ ಬರ್ತೀವಿ. ಇದನ್ ಬಿಟ್ಟು ಯಾವ್ದಾದ್ರು ಸ್ವಲ್ಪ ಡಿಫರೆಂಟ್ ಆರ್ ಯೂನಿಕ್ ನೇಮ್ ಇದೆ ಅವೆಲ್ಲ ಮೈನರ್ ಮಿನರಲ್ಸ್ ಅಂಡರ್ ಬರುತ್ತೆ. ಸೊ ಮೈನರ್ ಮಿನರಲ್ಸ್ ಅಂತ ಬಂದಾಗ ಇಟ್ ಈಸ್ ಅಂಡರ್ ದ jurisdiction of the state governments. So state government can make rules, it can prevent illegal mining, it can establish district mineral foundation. Mining ಮಾಡಿದಾಗ there will be certain section of people who will be affected, and those people will be taken care by district mineral foundation which are appointed by the state government itself. But ya mineral major mineral agate, ya mineral minor mineral agate, that is governed by MMDR Act, and MMDR Act is been formulated by whom? Parliament. So that is why previous statement alli in India central government has the power to notify minor minerals under relevant law. This is why they have given this statement. We'll move to next question. Panchayats at the intermediate level exist in all states. All anta bandaga be extra careful. To be eligible to be member of panchayat at the intermediate level, a person should attain the age of 30 years. Numbers kotta, be careful. Chief Minister of a state constitutes a commission to review the financial position of panchayats. Okay. See idral nodi, we know panchayat raj system in India is a 3-tier system. But if you study panchayat chapter properly, then we know that there are certain states where the population is very less and we cannot constitute a 3-tier panchayat there. So in such states where it is less than 20 lakh, if the state population is less than 20 lakh, there we have 2-tier system. So other basis ಮೇಲೆ one wrong ಆಯಿತು. ಇದು knowledge part ಗೊತ್ತಿರಬೇಕು. And to be eligible to be a member of panchayat, we know that the age that is needed is 21 years. ಇದು ಕೂಡ knowledge part ಗೊತ್ತಿರಬೇಕು. So one wrong, 1 and 2 are wrong. So it is A or D. Chief Minister of a state constitutes constitutes a commission to review the financial position. See, financial position of panchayats or state finance commission ಯಾರು ಅಪಾಯಿಂಟ್ ಮಾಡ್ತಾರೆ ಸ್ಟೇಟ್ ಅಲ್ಲಿ? ಇಟ್ ಈಸ್ ದ ಗವರ್ನರ್ ಅಂಡ್ ನಾಟ್ ದ ಸಿಎಂ. ಸೊ ಸಿಎಂ ಗವರ್ನರ್ ಇದ್ದ ಜಾಗದಲ್ಲಿ ಸಿಎಂ ಕೊಡ್ತಾರೆ, ಪ್ರೆಸಿಡೆಂಟ್ ಇದ್ದ ಜಾಗದಲ್ಲಿ ಪಿಎಂ ಕೊಡ್ತಾರೆ. ಲೈಕ್ ಐ ಸೆಡ್ ದೇರ್ ಫೈನಾನ್ಸ್ ಮಿನಿಸ್ಟರ್ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ಪ್ರೆಸಿಡೆಂಟ್ ಇತ್ತು, ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ಪ್ರೈಮ್ ಮಿನಿಸ್ಟರ್ ಮಾಡಿದ್ದಾರೆ. ಸಿಮಿಲರ್ ಥಿಂಗ್ ಇಸ್ ಅಪ್ಲಿಕೇಬಲ್ ಹಿಯರ್. ಸೊ ದ ಆನ್ಸರ್ ಟು ದಿಸ್ ಕ್ವಶನ್ ಇಸ್ all three are not correct. We look into next question. Who among the following are members of jury to select the recipient of Gandhi Peace Prize? This was a bouncer. Group B, Group C, Group D exams ಹೋದವರು ಗಾಂಧಿ ಪೀಸ್ ಪ್ರೈಸ್ ಬಗ್ಗೆ ಓದಿರ್ಬೋದು, ಬಟ್ ಇನ್ UPSC ಆಸ್ ಸಚ್ ಈ ತರ ನಾವು ಇನ್ ಜನರಲ್ ನಾವು ಓದಕ್ಕೆ ಹೋಗಲ್ಲ. 2021 PYQ will also I have highlighted. They had asked questions on sports. They had asked question on these sort of things like prizes and awards. But every year ಆತರ ಬರಲ್ಲ. But 21 ಅಲ್ಲಿ ಕೇಳಿದರೆ 25 ಅಲ್ಲಿ ಕೇಳಿದ್ದಾರೆ. That means one basic idea ಇದ್ರೆ okay, but do not try to it because ಬಂದ್ರು exactly answer ಮಾಡಕ್ಕಾಗತ್ತ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. We look at this. Who among the following are members of the jury to select the recipient of Gandhi Peace Prize? Okay, ಇದು ನಮಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ this was better meant to be left. ಇಲ್ಲ, if we have to take guesswork, what is that we could have done? Have we discussed about Bharat Ratna Award? Yes, we have. Have we discussed about Bharat Ratna Awards? We have. So what did I tell there? In there, I said that Bharat Ratna Award, it is the Prime Minister who will tell for whom it should be given, and he'll be telling it to the President because it is President who will give. But who will tell? Who is the jury while deciding it? I said he is the Prime Minister. So Prime Minister is a person who is to be included, and whenever this Prime Minister will come, then President will not come together. Prime Minister ಮತ್ತೆ President ಯಾವ್ದೇ ನೀವು ಆಫೀಸ್ ತಗೊಳ್ಳಿ ಅಥವಾ ಯಾವ್ದೇ ಬಾಡಿ ತಗೊಳ್ಳಿ, Prime Minister could be clubbed with CJI or leader of opposition or with any of the cabinet ministers. President ಮತ್ತೆ Prime Minister combine ಆಗಲ್ಲ because one is de jure, one is de facto. There's no point in involving both of them. And in this case, like we said, if you are able to recall, Bharat Ratna Award ಯಾರು ಸಜೆಸ್ಟ್ ಮಾಡ್ತಾರೆ? Prime Minister ಮಾಡ್ತಾರೆ. So 2 ಇರಬೇಕು, 2 ಇರಬೇಕು, 1 ಇರಬಾರ್ದು. ಅಂಡ್ ಇನ್ ದಿಸ್ ಕೇಸ್ 2 ಇದ್ರೆ 1 ಇರಲ್ಲ. ಇದ್ರ ಕೂಡ ಥ್ರೂ ನಾವು ಈ ತರ ಮಾಡ್ಬೋದಿತ್ತು. ಸೊ 3 ಇದೆ ಅಂತ, ಸಾರಿ 2 ಮತ್ತೆ 4 ಇದೆ ಅಂತ ಗೊತ್ತಾಗತ್ತೆ. ಬಿಕಾಸ್ ಇಫ್ ಯು ಲುಕ್ ಎಟ್ A and C, 2 and 4 are common. So whether 3 is there or not there, we could have done 50-50. Leader of opposition idre, then there is good chance. The answer is C. Basic idea, Gandhi Peace Prize, why is it given? There are people who have brought about changes through the means of non-violence. So to honor those individuals, there is this Gandhi Peace Prize which is being given, and there is a monetary benefit. Bharat Ratna, there was no monetary benefit. Here there is a monetary benefit, that too of 1 crore. Every year ಈ award ಕೊಡಬೇಕಂತಿಲ್ಲ, ಯಾವಾಗ ಬೇಕಾದ್ರೂ ಅವಾಗ, ಯಾವಾಗ there is necessity or when they find a relevant person, only then it is given, and only 1 award is given each year. Bharat Ratna by convention 3 awards are given in a particular year, though it is not been mandated, but here there is only 1 person who is given 1 award each year. Individual, association, institution, organization, any of this could be given, and the work should have been done within 10 years. Only then it is valid. So jury, Prime Minister, Chief Justice, Leader of Opposition ಇದನ್ನ ಇನ್ವಾಲ್ವ್ ಮಾಡುತ್ತೆ. See, Gandhi Peace Prize and then next year ಇನ್ನೂ ಯಾವ್ದೋ ಅಂತ ಕೇಳ್ಬೋದು. So there is no point in mugging up each of this committee and or the jury. So ಅದಕ್ಕೆ ಹೇಳಿದೆ less emphasis needs to be given there. And the information of the static part which I discussed also was just for a basic knowledge. ಇದರಿಂದ ಬರುತ್ತೆ ಅಥವಾ ಗಾಂಧಿ ಪೀಸ್ ಪ್ರೈಸ್ ರಿಪೀಟ್ ಆಗೋ ಚಾನ್ಸಸ್ ಇಸ್ ವೆರಿ ಲೆಸ್. Consider the following statements about Lokpal. The power of Lokpal applies to public servants of India, but not to Indian public servants posted outside. I have already said this, but not this. ಈ ತರ statements wrong ಇರುತ್ತೆ because Lokpal is applicable even to Indian public servants posted outside, such as the bureaucrats or the ones or the ambassadors who are selected through Indian Foreign Service based on UPSC. Chairperson or member shall not be a member of parliament or member of legislature of a state or union territory, and only the Chief Justice of India, only the Chief Justice of India has to be its chairman. Idu kuda, if you are able to recall, any body that is there, whenever they tell that the chairman could be Chief Justice of India, along with that it tells or he could be a Supreme Court judge. So yade body togoli, if the chairman can be Chief Justice of India, it will also tell that it could be a person from High Court of, it could be a Supreme Court judge. ಸೊ ಓನ್ಲಿ ಚೀಫ್ ಜಸ್ಟಿಸ್ ನ ಆಗಿರಲ್ಲ. ದಿಸ್ ಇಸ್ ಆಲ್ಸೋ ರಾಂಗ್. ಸೊ 1 is wrong, 2 is wrong, 1 is wrong, 2 is wrong, C is wrong, B is wrong. Lokpal cannot inquire into the allegations of corruption against the sitting prime minister. This is also wrong. So A na D na ಹೇಳಬೇಕಿತ್ತು. ಸೊ ಎ ಮತ್ತೆ ಡಿ ಮಧ್ಯ ಹೆಂಗೋ ಸ್ಮಾರ್ಟ್ ಗೆಸ್ ವರ್ಕ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೋದು. ಬಟ್ ಇಫ್ ಯು ವಾಂಟ್ ದ ರೈಟ್ ಆನ್ಸರ್ ದೆನ್ ಯು ಶುಡ್ ಹ್ಯಾವ್ ಸ್ಟಡಿಡ್ ಲೋಕ್ಪಾಲ್ ಬಿಕಾಸ್ 3 ವಾಸ್ ಕರೆಕ್ಟ್. UPSC ಈ ತರ ಮಾಡ್ತಿದೆ, ಪ್ಯೂರ್ಲಿ ಸ್ಮಾರ್ಟ್ ಗೆಸ್ ವರ್ಕ್ ಅಲ್ಲಿ ಕೂಡ ಕೆಲವು ಕಡೆ ಆನ್ಸರ್ಸ್ ಈಗ ಬರ್ತಿಲ್ಲ, ಅನ್ಲೈಕ್ ಇಟ್ ಯೂಸ್ ಟು ಹ್ಯಾಪನ್ 3-4 years ಬಿಫೋರ್. ಸೊ ದಟ್ ಈಸ್ ವೈ ವಿ ನೀಡ್ ಟು ಹ್ಯಾವ್ ದಿಸ್ ನಾಲೆಜ್. A chairperson should not have been less than 45 years. This is one of the things which is mentioned in the Lokpal. ಆದರೆ ಇದನ್ನ ಓದಿಲ್ಲ ಅಂದ್ರೆ ನಾವೇನ್ ಮಾಡ್ತಿದ್ವಿ, ಡಿ ತಗೊಂಡ್ಬಿಡ್ತಿದ್ವಿ. ಬಟ್ ಆನ್ಸರ್ ಇಸ್ ಎ. Lokpal jurisdiction, public servants posted outside also, like I said, former chief justice or former judge of Supreme Court. ಈ ವೇಡ್ ಯಾವಾಗಲೂ ಜೊತೆಗೆ ಇದ್ದೇ ಇರುತ್ತೆ, ನೀವು ಯಾವ ಬಾಡಿನಾದ್ರೂ ನೋಡಿ. As per Lokpal Lokayukta, minimum age of chairperson should be 45 years. This is not which we would have expected. And even the prime minister is subjected to Lokpal, only he is not subjected if it is under certain specified conditions such as international relation, internal security or atomic energy. ಈ ತರ important matters ಬಂದ್ರೆ then Lokpal power shall not be applicable over prime minister. So this was all about it. So ಈಗ ನಾವು 2020-25 ವರೆಗೂ 6 years Polity PYQs ನ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ವಿ. You yourself, if you watch my video from 2020, 21, 22 order wise ನೀವು ನೋಡಿದ್ರೆ you yourself will see that there are so many questions which have been repeated. 2020 ನೋಡಿದ್ರೆ 2021 ಬ್ಯಾಕ್ ಟು ಬ್ಯಾಕ್ ನೋಡಿ. ಸೊ ನಿಮಗೆ ಅರ್ಥ ಆಗುತ್ತೆ, ಸೋ ಮೆನಿ ಟಾಪಿಕ್ಸ್ ಸಿಮಿಲರ್ ರಿಪೀಟ್ ಆಗಿದೆ. ಸೋ ಮೆನಿ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಪ್ರೆಸಿಡೆಂಟ್ ಜಾಗದಲ್ಲಿ ಗವರ್ನರ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಗವರ್ನರ್ ಪ್ರೆಸಿಡೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸಚ್ ಆಸ್ ಪ್ರೆಸಿಡೆಂಟ್ ಪವರ್ ಅಂಡರ್ 5th schedule, ಅಲ್ಲಿ ಗವರ್ನರ್ ಅನ್ನು ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಥವಾ ಪ್ರೆಸಿಡೆಂಟ್ ಶೆಡ್ಯೂಲ್ ಟೈಮ್ ನ ಡಿಕ್ಲೇರ್ ಮಾಡಬಹುದು ಇನ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಸ್ಟೇಟ್ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಅಲ್ಲಿ ಗವರ್ನರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಈ ತರ ತುಂಬಾ ಸತಿ ಥೀಮ್ಸ್ ಬರ್ತಿದೆ. ಅಂಡ್ ಯು ವಿಲ್ ಆಲ್ಸೋ ಸಿ ದಟ್ ದೇರ್ ಆರ್ ಸರ್ಟನ್ ಬೌನ್ಸರ್ಸ್. ಈ ಸತಿ ಗಾಂಧಿ ಪೀಸ್ ಪ್ರೈಸ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅಥವಾ ಅರುಣಾಚಲ್ ನೇಮ್ಡ್ ಆಫ್ಟರ್ ಅ ಫೋರ್ಟ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ದೇರ್ ಇಸ್ ನೋ ಪಾಯಿಂಟ್ ಇನ್ ಚೇಸಿಂಗ್ ಸಚ್ ಥಿಂಗ್ಸ್. ಈಗ ನೀವು ಎಲ್ಲ ಈ ತರ ಸ್ಪೆಸಿಫೈಡ್ ಥಿಂಗ್ಸ್ ನ ಓದ್ತಾ ಕೂತ್ಕೊಂಡ್ರೆ ಟೈಮ್ ಇಲ್ಲ. ಈ ತರ ಓದ್ತಾ ಕೂತ್ಕೊಂಡ್ರೆ UPSC ನೀವು ಓದಿಗಿರೋದೇ ಕೊಡುತ್ತೆ. ಬಿಕಾಸ್ ಇಟ್ ವಾಂಟ್ಸ್ ಟು ಟೆಸ್ಟ್ ಯು ಅಂಡರ್ ರಿಯಲ್ ಕಂಡೀಷನ್ಸ್. ಇಟ್ ವಿಲ್ ಟೆಸ್ಟ್ ಯುವರ್ ಪೇಷನ್ಸ್, ಇಟ್ ವಿಲ್ ಟೆಸ್ಟ್ ಯುವರ್ ಆಟಿಟ್ಯೂಡ್. ಭಯ ಪಟ್ಬಿಟ್ಟು ಕ್ವಶನ್ ಸ್ಕಿಪ್ ಮಾಡ್ತೀರಾ, ಭಯ ಪಟ್ಬಿಟ್ಟು ನನ್ನ ಎಕ್ಸಾಮ್ ಮುಗೀತು ಅಂತ ಅನ್ಕೊಂತೀರಾ, ಅಥವಾ ಕೂಲ್ ಅಂಡ್ ಕಾಮ್ ಆಗಿದ್ದು ನೀವು ಕ್ವಶನ್ಸ್ ನ ಅಟೆಂಪ್ಟ್ ಮಾಡಿ ಕರೆಕ್ಟ್ ಬರ್ತೀರಾ. ದ ಒನ್ ಹೂ ವಿಲ್ ಬಿ ಬೋಲ್ಡ್, ದ ಒನ್ who will be confident, the one who will be calm will emerge out victorious. This has been seen across the years. So 2026 we do not know what sort of paper is coming, but in a general sense 22-24 static ittu, 23-25 ಸ್ವಲ್ಪ similarity, more dynamic paper ittu. So 2026 we can expect good number of static questions. So static syllabus ಏನಿದೆ, please have a very good hold. Dynamic questions ಬಂದ್ರೆ we will have to answer it on spot, but static questions ಏನ್ ಇದೆ, these are pocket marks. We cannot afford to make mistake in this. So this was Polity. I hope you watched all the videos that I have done on Polity, and I hope you enjoyed it. Thank you for watching.